I predicted in a prior video that Judge McAfee, the judge overseeing the criminal RICO case against Trump and other defendants in the state court in Georgia, would allow Trump and the other defendants to appeal his order that allowed Fani Willis and the other attorneys in her office to remain on the case. I will link that video in the More section below. The appellate court now has 10 days to decide whether to take the case. I believe that it will. Judge McAfee found that Trump and the other defendants did not carry their burden of proof, showing an actual conflict of interest sufficient to remove Willis from the case. But there was sufficient evidence of an appearance of impropriety that required, in McAfee's opinion, that either Willis or Nathan Wade step down, which would be a sufficient cure of the ethical issue in the court's opinion. Wade later resigned in response. A question on appeal is whether an appearance of impropriety, which stops short of an actual conflict, requires that all prosecutors be removed from the case, which is a most drastic remedy. The prosecution is not stayed pending the appeal of this order. Judge McAfee may continue to rule on other motions that are already before the court. I doubt that any new motions will be filed by Willis when McAfee's order is being appealed. Willis does need to find a competent lawyer with experience to take Wade's place while this appeal is pending, and to use the time to bring him or her up to speed on the case. As I said earlier, Willis, at a minimum, exercised bad judgment in hiring someone as lead attorney who had no prior experience handling this kind of case, and then engaging in a relationship with him. On appeal, Willis will benefit, in my opinion, as she did in the lower court, from the defendants having the burden of proof on this issue. McAfee may have removed both Willis and Wade if they had the burden of proving there was no actual conflict. Willis will also benefit from the judge's factual findings about the testimony, which are not proper subjects of judicial review of the legal issue that's presented. And given the importance of the prosecution and the claims being made, I doubt that an appellate court would dismiss Willis and her office based just on a finding of appearance of an impropriety that had been cured by Wade's removal from the case. I certainly do not foresee the appellate court dismissing the case under those grounds. But if the appellate court does require Willis and her office to be removed, but allows the case to proceed with new prosecutors, then there is a process in Georgia where another prosecutor can be appointed to take over the case, or, once appointed, decide to dismiss it. A state panel called the Prosecuting Attorney General's Council of Georgia would be convened to identify a new prosecutor to take the case if Willis was dismissed, which would result in a trial delay at a minimum. The new prosecutor appointed in that manner would have the sole discretion of deciding whether or not to proceed with the prosecution. And I would say that given the likely appointed person in Georgia, that more likely than not, a decision would be to refrain from proceeding once Willis was removed by the appellate court in a decision that is yet to come.